Welcome to Architectures of Access, a journey through India's alternative dispute resolution ecosystem. At the very foundation of our legal structure sits Article 39A, which acts as the constitutional engine driving the system. This crucial directive principle establishes a clear mandate for equal justice and free legal aid. It serves as the vital origin point, transitioning our legal landscape from abstract constitutional philosophy into a functional, statutory reality specifically designed to build a true welfare state. This mandate is implemented through NALSA, the National Legal Services Authority. It operates through a three-tier hierarchy. The national authority led by the Chief Justice of India as the patron-in-chief, state legal services authorities led by the Chief Justice of the State High Court, and district legal services authorities headed by the district judge. The authority also publishes an official newsletter titled Nyay Deep. Who does this reach? Free legal aid serves those with structural vulnerabilities, such as members of scheduled castes, SC, and scheduled tribes, ST. It also supports those facing economic hardship, such as industrial laborers and low-income individuals as determined by the state. Additionally, it assists individuals facing circumstantial challenges, such as the mentally ill, victims of disasters or calamities, individuals in custody, and victims of human trafficking under Article 23. Finally, the framework provides protection for specific demographics, including women and children. Introduction to Lok Adalat. Enter the Lok Adalat. Ancient roots. It is built upon ancient, historical forms of the judicial system that were once prevalent in ancient India. Philosophical basis. Furthermore, it is deeply rooted in the Gandhian philosophy of Gram Swaraj, which emphasizes village self-governance and community-based dispute resolution. The intersection. Ultimately, the Lok Adalat serves as a vital forum where both pending cases and disputes at an initial stage can be settled amicably, offering an alternative to our overburdened courts for achieving speedy and cost-effective justice. 1982. The first experiment. The Lok Adalat concept began as an experiment in Gujarat in 1982 to explore alternative grassroots dispute resolution. 1987. Statutory status. It was later enacted and institutionalized via the Legal Services Authorities Act, 1987. Present. Legal weight. In the present day, a Lok Adalat award is officially treated as a civil court decree. Finality of the award. The decision is final and binding. No appeal lies against the decision itself, though dissatisfied parties maintain the right to file a fresh case in a court of appropriate jurisdiction. Anatomy of a Lok Adalat. Who makes up a Lok Adalat? Establishing authorities. These forums are established by the Supreme Court Legal Services Authority, the High Court, or the state government. The composition of the bench. The bench is composed of a three-part structure. A judicial officer, either serving or retired, a lawyer who provides legal rigor, and a philanthropist who brings social empathy to the process. Lok Adalats handle pending and pre-litigation matters, as well as compoundable criminal cases that can be settled by mutual agreement. However, there are strict limitations. A Lok Adalat cannot issue divorce decrees, and it is important to clarify that they do not hold authority over non-compoundable criminal cases. The resolution process is defined by four key pillars. Access. There are no court fees or stamp duties applied, with the entire expense borne by the Legal Service Authority. Flexibility. There is no strict application of procedural laws or rigid legal technicalities. Process. Proceedings are formally recorded, with the absolute focus on achieving a mutual agreement between the parties. Resolution. An award is granted, and the decision is final, binding, and unchallengeable via appeal. The system is further refined through a diagnostic matrix of Lok Adalat variants. First, the National Lok Adalat operates across all court levels from the Supreme Court to the Taluk level and, since February 2015, has been organized monthly to focus on specific thematic topics. Second, the Permanent Lok Adalat, established under Section 22B of the 1987 Act, is a permanent body consisting of a chairman and two members that focuses on the conciliation of public utility services, such as transport and postal matters, for disputes up to 10 lakh rupees. Finally, the Mobile Lok Adalat acts as a traveling forum that moves physically from one location to another with the objective of bringing grassroots dispute settlement directly to rural and remote communities. To further alleviate the burden on formal courts, India introduced the concept of plea bargaining. formally granted statutory recognition via a 2005 amendment to the Code of Criminal Procedure, CRPC. This mechanism shifts the focus from adversarial trials to mutual, out-of-court agreements between the parties. While plea bargaining offers a path for resolution, it is subject to a strict exclusion filter. The system cannot be used for all crimes. It explicitly excludes cases where the offense carries a punishment of 7 years or more, as well as offenses committed against women. Furthermore, it prohibits plea bargaining in cases involving children aged 14 or below, or offenses that significantly impact our nation's socio-economic reforms. In summary, the ADR ecosystem orbits the citizen. NALSA acts as the engine, providing the necessary hierarchical structure and funding for free legal aid. Lok Adalats serve as the venue, functioning as the primary community and institutional forum for resolving disputes through tradition and mutual agreement. Plea bargaining acts as the tool, a statutory, out-of-court procedural mechanism designed to alleviate the burden on formal criminal courts. Working in tandem, these elements fulfill the mandate of Article 39A, democratizing justice across India. Don't forget to subscribe, like, share, comment if you enjoyed this quick revision.